the Chesapeake Beach Ethics Commission on February 10th, 2021 at 1 p.m. First order of business is the Pledge of Allegiance. Bring you a flag into this.
I pledge allegiance to
The
the flag
The flag
of the
of
United
the
States
States of America.
and to the republic
For
for which
which it stands,
one nation
nation,
under
under
God,
God,
indivisible,
indivisible,
with liberty
liberty
and
and
justice
justice
for all.
for all. Amen.
Okay, next item. I lost. The next item is approval of the minutes of the January 21st meeting. These were distributed electronically a couple of days ago. Does anyone have any corrections or improvements?
No,
All right, that being the case, they are approved. All right, next item is proposed changes in the ethics ordinance. And I had sent a draft around on the 8th. Fred responded with a number of changes, all of which made sense to me. So I sent out this morning a version which incorporates all the changes that Fred suggested, I hope. If anyone, sort of thing I try to do and sometimes I'm not successful. Are we ready to go through these and if possible, approve them and make them recommendations to the town?
Sounds good.
Okay, first one is in section 2516. The current ordinance says where conduct presents an appearance of a conflict of interest, etc. The proposal is to change that to where conduct might present an appearance of a conflict of interest. Does anyone have any discussion of that?
no,
No, that sounds good.
Okay, I'm going to move that we, how do we say this? Recommend the adoption of this by the town council. And without dissent, it's been agreed to. Let me write it down. Move, recommend adoption by the council. Okay. Next one, the heading of 2523. The suggestion is, well, it currently says employment and financial interest restrictions. And the suggestion is to add the word service in there. So there's, would indicate there are restrictions regarding employment, regarding service, and regarding financial interests. Is there any discussion of that?
Sounds good, Phil.
Okay, all in favor of recommending adoption by the town council indicate by saying aye.
Aye.
I,
Aye, okay. All right, in 2523B, it currently says a covered person may not be employed by or have a financial interest in, and then it lists several things. And the suggestion is to change that to say a covered person may not be employed by, have a financial interest in, or serve as an officer or director of any entity. And then list these things. Any discussion?
No,
All those in favor of recommending adoption by the town council indicate by saying aye.
aye.
I,
Passes. Also 2523B, the suggestion is to add, currently B says you can't be employed by, et cetera, any entity that is, one, subject to the authority of the town, or two, that is negotiating or has entered into a contract with the town. Suggestion is to add a 3 or 3 that requests or receives a grant or other funding from the town. Any discussion?
No.
No,
All in favor of recommending adoption by the town council indicate by saying aye.
aye.
Passes unanimously. 2526 concerns use of prestige of office. It currently says a covered person may not intentionally use the prestige of office, etc. The suggestion is to add or make that a covered person may not knowingly or intentionally use the prestige of office. Any discussion?
Phil, why do we need knowingly? What is
I think what it changes is if it's intentional, you have to prove the state of mind of the official.
oh, okay.
And that happens in a lot of criminal and civil cases. It's legitimate to do that. I'm suggesting that we reduce the standard so that there's a violation if you know that you're using this prestige of office.
Oh,
That's
okay.
all.
Makes sense.
Any further discussion?
No.
Those in favor of recommending adoption by the town council indicate by saying aye.
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 Passes unanimously. All right, in 2527B, starts out, covered person may not knowingly accept a gift directly or indirectly from a person that the official or employee knows or has reason to know, etc. Suggestion is to change that to say from a person or entity that the official or employee knows. I think that's just, it eliminates a unnecessary ambiguity. Obviously, you don't want people accepting gifts from companies that are among those, for example, that are doing business with the town. Right now, it says a person, and if there were a case brought, we'd have to argue that person indicates companies as well as human beings. This way, we eliminate that ambiguity.
Yep.
No further discussion. All those in favor of recommending this change to be adopted by the town council indicate by saying aye.
Aye.
Okay. Lastly, in 2527, there's a 2527B lists a number of now entities that you can't accept a gift from. The suggestion is to add the following, the number 4, an entity that has or is likely to request or receive a grant or other funding from the town. Any discussion?
No.
Those in favor of recommending adoption by the town council indicate by saying aye.
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 All right. Article 4 title currently says financial disclosure by elected officials, candidates, and appointed officials. Even in the model, the state model language, there is a requirement to disclose certain things which are not financial. For example, name any member of your family who works for the town. It seems to me that, again, we could have a court fight if somebody lies about that and says, well, that's not a financial disclosure. So I think we'd be better off with, say, throughout the ordinance, talking about public disclosures.
Makes sense.
Any discussion? Makes sense? All right, those in favor of changing, I got to read into the record. Right now it says financial disclosure, it would be changed to say public disclosures by elected officials, candidates for election, and appointed officials. All those in favor of making that recommendation?
I have
indicate
one
by-
comment before you vote.
Yeah.
And you may have fixed this with your new update, because I only have the one on the 8th. But I noticed that you didn't change the public disclosure throughout the document.
It was- I thought I did. That's
I found quite a few places just in the thing you sent out on the 8th. So
Okay.
I would just tell you you might be good to just add that right now and say to change it throughout the document.
I think that is a good idea. Does anyone see any problem with that?
No,
All right, so the motion is to, I have to write this down, change financial disclosure to public disclosure throughout the ordinance. Does anyone see any problem with that? Or want to have any questions about that?
no.
All right, and I'm going to correct what I said. I didn't go through and try to make that change. I had it on my list of things to do. Forgot. All right, all those in favor of recommending this change adoption by the town council indicate by saying aye.
Aye.
Okay, 2532. All right, and this is deadlines for candidates, I'm sorry, 2532B is deadlines for statements by candidates for elected office. In addition to making the change from financial to public, clarifying if this is what we want to do, the candidate shall include a disclosure statement covering the preceding calendar year.
Bless
Bless
you.
you.
Thank you.
All right.
Excuse
Now, we could say the preceding calendar year plus the part of the current year, but I don't see, well, that would be requiring more disclosure than is provided by an incumbent. I think this puts everybody on the same level. If you're running, you must disclose this information regarding the preceding year. Does anyone have any trouble with that?
Read over again, Phil.
Sure. It would say candidates for elected office, including incumbents, shall include disclosure statement covering the preceding calendar year, along with their declaration of candidacy.
Okay.
What about that period of January through before they file?
Yeah.
Well, that's, if you want that, let's discuss that.
Because I know
But
we
right
talked,
now, if I understand it, the incumbent, let's say the election is in October. Let's say we're having an election in 2021. The incumbent running for re-election will have done a disclosure for the year 2020 in April, right? And
Yeah.
he can run without any further disclosure.
Right.
Correct the 2020, but he doesn't have to provide any information about 2021. The suggestion here is to make clear that a non-incumbent candidate has to provide the same coverage of disclosure as just for the calendar year 2020.
But Phil, if the commission is inclined, both candidates and incumbents would still be on the same footing if you wanted to cover that period, January 1 until the date of filing.
Yeah.
That is correct.
because that's what we talked about at the last meeting, and I guess the quandary was, as Randy brought up, that date of filing is a moving target. It could be as early as May 1st, it could be July 1st, it could be August 1st. that was sort of the sticking point as I remember it.
Yeah, I thought we were looking towards going towards a set date, let's say July 1st of the year of the election, that
Yep. We talked about that too.
Yeah, but that really doesn't work if somebody is going to file in or prior to July 1st. If they're going to file in May or April, July 1st hasn't come yet, so they can't just close up to that point in time at the time of filing.
I wouldn't worry about that if you specifically say that it has first or July 1st and he files early, he's just going to have to update it because my election code says in accordance with your 22 dash or your, with your chapter 25. So if you put in there that that's when he's got to do it to that date, then that's when he'll have to do it. And that's what I'll have to have when he files. Now, I wouldn't make it any later than August 1st. I mean, I wouldn't make it like September or something, but August 1st or July 1st is when very few people filed before July 1st. In fact, I think this last time nobody did. The first one to file was during July, and it was the mayor.
Well, why don't we go with August 1st?
Sounds good to me.
I don't have an issue with that. And if it's in writing, Fred, then he's going to have to comply with it, right?
Well, I think we're going to need to add something that if the certificate of candidacy is filed prior to August 1st, then the public disclosure will have to be updated for the period between date of filing and August 1st.
Yeah, that's
I
reasonable.
wouldn't want to leave that ambiguity.
Yeah, the real ambiguity is that we don't mention how early they can file. And so if you actually put in a date onto the disclosure, now there's an official date.
That works.
But I don't have any problem with you adding something, Fred, about having to update it if they file prior to that.
The other option is not required to be filed with the certificate of candidacy, but just have a separate filing requirement not later than August 1st or as of August 1st for the public disclosure. Keep them separate.
Not a problem that have to be overcome is I believe we'd have to amend the election code.
That's not a
No.
big deal. I mean, there's a couple of words I might have to change in there. I don't see a problem with that.
All right, I don't think I can come up with this on the fly. I'm afraid we're going to have to ask a motion being, do we agree in principle to change this so that all candidates must have filed for the preceding year and the current year through July 30th. And if that motion passes, we're going to have to come back to it at a future meeting in order to.
Fred, July 30th or July 31st?
I'm sorry, July. It's 30 days, that's September. July 31st.
Right on top of that, Ingrid.
Does that make sense? We're going to have to agree in principle or disagree. And between Fred and me, at least, maybe Randy, come up with language that would accomplish that.
That sounds
Those in
good.
favor of that motion indicate by saying aye.
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 All right, it's passed in principle. At the same time, in the same section, we're proposing to add that whatever the filing requirement is and the deadlines are, it be, quote, in accordance with section 2526A of this code. Does anyone disagree in principle with that?
No.
The whole
No.
section is going to have to come back to you guys. All right, the next thing is that the current ethics ordinance talks about the town clerk forwarding the disclosures to the ethics committee and the board of elections. That's B2. And that seems unnecessary. The election code, I believe, requires the disclosures by candidates to be submitted to the town clerk, who forwards them to the election board, which has its rule saying you can't be a candidate unless you have submitted. So it suggests taking out paragraph 2. If there's no discussion, those in favor of recommending section 2532B2 be removed from the code indicate by saying aye.
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 That's approved. All right. And then the last section is the current law requires us to inform the elections board by a certain deadline that of any case in which the financial disclosure is facially incomplete or defective. And I think we discussed that last couple of times around that. Although the implication of that is that that person can't be a candidate if we or somebody determines that the disclosure is facially incomplete. It appears that the view of the election board is that they don't think that the law should be that if there's an incomplete disclosure, the person can't be a candidate. The law says only you must submit a disclosure by a certain deadline, which we're going to have to deal with. So removing this would eliminate an unnecessary burden on us, a useless burden. And I can only thank the Lord that this didn't come up last time. Any discussion, Ingrid or Mike?
No, that sounds good.
No.
Okay, all in favor of recommending to the town council to delete section 2532B3, indicate by saying aye.
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 Those opposed, no. The ayes have it.
And for the recording, I, as Board of Elections, concur with that.
Thank you. Have that in the minutes, please, Sharon. All right, 2533. Again, we lucked out on this last time. The current ordinance doesn't happen to say, it says what elected officials have to submit. Doesn't say what candidates have to submit. So the suggestion in both of those is to change the phrase for elected officials, a list of, etc. And make that in both cases for elected officials and candidates for election. Any discussion?
Nope.
All right, those in favor, well, let's make one more within that. Also in 2533, instead of saying at the end, and for each property of the elected official, a statement of, change that to, and for each property of the filer, a statement of.
Yep.
Okay. All in favor of recommending those changes to the town council indicate by saying aye.
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 Aye. Not hearing any no's. All that passes. Okay. 2534.
Hey, Phil, if I could interrupt for a second. I'd like to take you back to 2532B, where it says election code 22-26A.
Yeah.
I just looked it up and it's not actually in 2226A that it records. It's in 2226, but actually B7.
Okay, B as in boy.
I would, yes, I would suggest that you, if Fred concurs with this, I would suggest that you do what I did in the election code, which I just referred to the ethics part as chapter 26.
Uh-huh.
I didn't mention a particular paragraph.
Okay, here's what we're gonna do. Either Fred or I will do a draft and circulate it. And then everybody, it'd be nice to receive any comments by email before the next meeting. And that's, at the moment, I'm persuaded, but I haven't thought about it.
Yeah,
Okay.
no problem. I just noticed that that was an error.
Okay. All right, 2534, the heading is Commission Review and Enforcement. And the notion is do a couple of things. All right, filers are, okay. Right now it says that we should notify the person submitting the statement of any omissions or deficiencies. And it says which the person shall remedy within 1 week after notice. I suggest we clarify omissions or deficiencies to add including a failure to sign or a failure to complete each form, which is what we've been doing.
Right.
Discussion there. Cross out, except that in the case of a candidate for election, such remedy shall be prior to the 43rd day before the election. That's with the election board's position that they, having that any alleged omissions corrected has no bearing on the person's eligibility to be a candidate. And then finally, and this is sort of, well, acting on a suggestion of one member of the council, the commission must investigate any violations of the ethics law which appear to be revealed in a person's disclosures. So there's no doubt anymore that we don't just look at it and look at its completeness. Once we're satisfied, or whether or not we're satisfied with completeness, we have to act on anything, any apparent violation, including, an example would be, let's say incumbent in 2019 discloses that his, in this case, spouse is an officer of a company with a large contract with the town. 2020, there is no such disclosure. Right now, could be that there's been a divorce, or the company's lost a contract, or the spouse has lost a job, right? But if we see something like that, then regardless of whether we proactively contact the person and say, gee, this looks strange, it's a false filing, signing under oath that there is no, that information. If it turns out we do an investigation and find out that the spouse is still the officer and the company still has a contract, or did in 2020, that this is as much a violation of the law as there being a conflict of interest. So the suggestion is that we add that we'll at least investigate anything that appears to be either a violation of the conflict of interest provisions or the disclosure provisions.
What do we do in a case where a person's running for office, hasn't been elected before? Would we also investigate?
I don't think there's a possible violation. Oh, I'm sorry. Actually, all right. So can't be a possible violation of the conflict of interest provisions. But yes, if the person files a false
Mhm.
statement, then, and whether or not the person's elected, I suppose, I think we are obliged to investigate what appears to be a false statement and act on it if the facts indicate an actual violation.
And we would only
Yeah.
act on it, investigate it at the point they became elected. Is that correct?
I don't think so. I mean, certainly there'd be, as we have later, we refer possible criminal charges to the state's attorney. There would certainly be the crime of perjury, right? I don't know. We'll have to think. Maybe we can discuss that when we get to, a couple of minutes when we get to the next
Okay.
major changes, because I'm not sure we've thought it all through. I mean, it's sort of like, well, what happens if the person's no longer an officer?
Right.
The violation occurred while the person was in office and has now been defeated for re-election or has resigned in January or whatever. All right, we'll get to that. Those in favor of adding a actual requirement that we investigate apparent violations of any part of the election ethics law that are revealed in the disclosure indicate by saying aye.
Aye.
We recommend-
Aye.
Okay. All right. 2535 is a standalone section that says we charge a $2 a day late fee, which at one point I tried to change to $5. And then my suggestion at this point is that be part of the 2539 enforcement. We have all the, whatever the penalties or results of violations of any sort be in one section. So with the understanding that late fees will be put into a later section, is there any objection to deleting 2535?
No.
No.
All right, all those in favor of recommending deletion of 2535 to the council for adoption indicate by saying aye.
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 Aye. Okay, 2536, sort of redundant to the suggested change in 2534. I think it's reasonable redunks. It adds, the section is commission investigation of possible violations. It currently says based on a complaint or information developed in connection with a request for advisory opinion, or in its review of information available to it, the commission may investigate. Suggestions are to add as a source of information, information provided in public disclosure statements, to add, instead of on its own review of information, make it clear on its own review of any other information, and change, we currently have the commission may investigate possible violations to the commission shall investigate possible violations. Any problems with any of those?
No.
Okay. Sounds good.
Those in favor of recommending to the town council that it amend 2536 as shown here indicate by saying aye.
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 Aye. Okay. 2538 has been taken care of by the Getman suggestion. anywhere it says financial disclosure, change it to public. That was the only thing there. All right. Current 2539 is entitled Judicial Enforcement. 2540 is disciplinary action. 2540 would go into the overall enforcement section that is before you. 25, a new 2539, or I suppose it'd have to be 2538, but we'll take care of the numbers. All right, here are the suggestions. Well, here are suggestions. If there are no material facts in dispute, the commission will hold a non-evidentiary hearing, we'll listen to all sides, and issue a decision as to whether there's been a violation of the ordinance. That's A. B, if there are material facts in dispute, the town, at our request and with the consent of the budget authorities, may contract with a qualified person to hold a hearing, recommend findings of fact, and then the commission, then after opportunity for the parties to make arguments, will issue a decision. All right, now, question arises. What happens if we go to the town? We have a case. There is a dispute over the facts that would go into a violation. We go to the town and say, we need to have a hearing to look at this set of disputed facts. And the town says, no, we're not going to spend the money. My suggestion is, no, I can't. No, I don't have a suggestion. Fred, I noticed in your draft, you had actually a hidden note there asking this very question.
Yeah. And I don't
What's the
have a
answer?
suggestion. I don't have a suggestion.
So, I mean, without anything, then, it's on the town council.
Right.
Right.
I mean, it's a decision they made. They made a decision not to spend the money. And so you can't go forward and you're not giving them due process.
Yeah.
So,
Okay, if we all understand that, that's what that's what I'll explain to the council. They choose not to, then that's that, and it's not our fault.
right.
All right, so let's, those in favor of, well, let's take one at a time. Recommending the new 2539A that talks about cases where there's no material facts in dispute. Those in favor of recommending adoption indicate by saying aye.
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 Those opposed, no. The ayes have it. 2539B is what we just discussed. Those in favor of recommending to the town council to adopt it indicate by saying aye.
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 Those opposed, no. The ayes have it. All right. 2539C is a decision by the commission may provide appropriate remedies and punishments. These may include, and the first one is assessing a late fee and change from the current $8 a day to $5, and say just two possible latenesses. One is failure to meet the deadline for filing. The other is failing to meet the deadline for responding to our statement of deficiencies. And that, by the way, would could have some effect on a candidate. least, candidate fails to do a Form A, we inform him, he doesn't do it. At least that's the candidate's opponents will be able to make something of that. First question is the amount of money. I think the state's model, I think, does say $5 up to a total of 500. No, I don't know how much is necessary to make this other than a joke.
Should we cap that, Phil? Just like you just mentioned, they had up to 500. Should we put a cap on it of some sort?
I don't see why. I mean, $5 and $500 is 100 days. It's three months. I would think we would hold a hearing and make a decision before that. My suggestion on this bit is it also be set aside for the next meeting.
Okay.
Think about both the amounts and whether we should put a cap on it.
All right.
Is there any dispute about adding this, that it's both a failure to file at all or a failure to correct by the 1 week deadline?
No.
In principle, that's okay. Okay. All right. Next, now the rest of this, I think, is taken from the model. We can, number 2, C2 is issue an order of compliance directing the respondent to cease and desist from the violation. 3 is issue a reprimand to the respondent, whatever that means. Recommend to the appropriate authority to suspend payment or salary or compensation pending full compliance with the order, and recommend other appropriate discipline, including censure or removal if that discipline is authorized by law. And a couple of months ago, I think Fred pointed out that for elected officials, it's probably not authorized by law. At least with the charter as it is, there is no way that a town council member can be removed, at least for a violation of the ethics law.
Okay.
All right. So that would be.
Phil, I thought, can a town council member be removed because of a violation of either a felony or a misdemeanor?
Yes. Yeah. That's
A
state law.
felony.
Is it just a felony?
Felony.
And that's state law. What appears not to be possible. Well, so here's what's possible.
Okay.
The head of an appointed official, we find violated the conflict of interest provisions, by acting on a matter which he or she is financially interested in. We recommend to the town council that person be fired. Or if it's, a lower officer, we recommend to that person's boss that the person be fired.
Mm-hmm.
That's at least legal. They can do that. What we apparently can't do is, we can recommend, we can waste our time. What can't happen is that on our recommendation, the town council or the mayor or somebody expels a council member.
Okay. But wouldn't we go, if they were in violation, we would ask the state attorney to take a
Yes.
look at it. And if the state attorney found after a court case,
Yeah.
then that would be a felony, and they would be.
No.
Well, it depends on what it is.
It-
If it's perjury, it's a failure to, if it involves perjury, that
Yeah.
is disclosure, that is a felony. If it's simply a conflict of interest, apparently it's not defined as a crime.
Oh, okay.
They are charter, I guess. Fred?
A conflict of interest, it would be a violation of the code.
Okay,
So it would not be a felony. It wouldn't be a misdemeanor unless somebody was charged as a misdemeanor, as I think they might be able to be for a violation. Just bear with me. I'm looking at the model on my screen, so I have to shift my focus. Let me ask this. Does the town's ethics ordinance make a violation of the ethics ordinance a misdemeanor?
does not now, doesn't say anything. I don't think.
Yeah, I don't recall seeing that,
No,
but
and I don't think that's in the model.
yeah, it is in the model. And
Really?
that's what triggered my question.
Oh, okay. Let's, again, at the next meeting, we will, and before that, we'll get a draft that adds that a violation of this ordinance is a misdemeanor.
Subject to a fine of not more than $1,000 or imprisonment for not more than 1 year. That's
Okay.
what's in the model. That's what's in the model.
Okay, I'm glad yeah, thank you. Okay, going back to now, I'm sorry, the section that says what the penalties that we can inflict. Does anyone have any further discussion?
No.
Right. Those in favor of recommending this list of possible remedies other than number 1, which has to do with the late fee, indicate by saying aye.
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 Those opposed, no. The ayes have it. So we're recommending numbers 2, 3, 4, and 5. Then 2539C.
It needs to be, we have 2 Cs, Phil.
Oh, we got 2 Cs, I see. From C to shining C. We're going to make the second C will be a D. And this is judicial enforcement. Again, I think what we have to have is, well, the draft is, upon request of the commission and subject to the availability of funds, the town attorney may file a petition for injunctive or other relief in the circuit court. And then the court may do the following things.
Phil, in thinking about it, we probably ought to add something in addition to the town attorney, because there may be circumstances under which the town attorney is conflicted.
Yeah.
So the town attorney or other attorney designated by the
Well, wait, we don't need that. We can just say the town may file a
town.
petition.
Yeah, that's
So
fine. That's good.
Strike attorney.
Mhm.
And it says may, again, it's a word, if they choose not to, then it's just a public relations thing. Then the rest of this is, I think, Fred, you hope, exactly what is in the model. which is issue a cease and desist order, order suspension of payment of salary and compensation, order removal of the respondent from his or her position if that discipline is authorized by law, void an official action under certain conditions. One is if the legal action is brought within 180 days of the occurrence of the official action. The model says 90 days, by the way. If the court deems that the action would be in the best, voiding the action would be in the best interest of the public. And then there are 3 exceptions. I'm sorry, paragraph III is can't be done, can't void the action if it's one that appropriates public funds, levies taxes, provides for the issuance of bonds, notes, or other evidence of public obligation. And finally, the court can impose a fine of up to $5,000 for any violation of the chapter with each day upon which the violation occurs, constituting a separate offense. I think the only thing where I'm suggesting deviation from the model is to say that the legal action has to be brought within 180 days rather than 90 days. I don't even know what's the purpose of that limitation at all.
Because these are interferences with the operation of government, and you want certainty for the government to be able to operate efficiently. So you don't want claims becoming or issues becoming stale and creating becoming stale and creating an impediment to government operations. If there are issues there, get them resolved reasonably promptly.
I can imagine, I mean, here, one of the things that happens is, take that back. I'll finish and then disagree with myself. There could be stalling. All right. So we have a thing where the town council votes in favor of a zoning change, for example. And sometime later, somebody files a complaint that says a council member was conflicted and shouldn't have voted on it. We investigate, we hold a hearing. We get the town council has to have a meeting at which they authorize expenditure of the money for us to hold a hearing. And we hold the hearing, make a decision. That could well be more than 90 days, I think. Through no fault, not through any laziness on our part. Fred, do you see a problem with a 6-month?
No, but also the other thing is that I think the way I'm reading this, the commission could bypass its hearing process and its determination process and go right to the council and ask to initiate, have the town initiate a proceeding in the circuit court and put it all in the judge's hands.
Okay, let me repeat that. What is currently the beginning part of D does not depend upon the commission having made a decision that there has been a violation.
That's the way I read it.
And so, and that would, as part of the answer to the, all right. That's not a good answer, but it's part of the answer to, we are denied the funds to hold a hearing. We then ask the council to take the allegations to the district court, circuit court. I guess on the theory, and then they might approve that because it's cheaper than paying a hearing examiner.
No, it's not going to, believe me, it's not going to be cheaper, Phil.
Yeah, but hey,
and it's not-
that's
Yeah, and there's
Theoretically.
nothing to say that the commission or that a hearing has to be held by a hearing examiner. If the council denies funds to hire a hearing examiner, the commission could, if it so chooses, conduct a hearing on its own.
Yeah,
Not that it's necessarily desirable, but that could always be a fallback position.
yeah, I mean, I want to avoid that like the flu, like
And I don't blame you.
fact. Well, all right. I guess we're not going to send any of this to the town council until the next meeting. That would require Fred going back to 2539B to say clearly that if we can, we can hold a hearing, factual dispute. So let's discuss that next time. So I'm not gonna, well, yeah, let's, now, there's no reason we can vote on D right now, unless anyone has any problems with the overall idea of being able to go to court.
Phil, before you take that vote, one other thought, and that is that there's nothing in this that would prevent somebody from going to the commissioner and requesting the issuance of a statement of charges for a criminal violation that would not cost the town a penny.
That's correct, and that's already in.
And that would be prosecuted by the state's attorney.
Yeah, and that's in current law, and we're not changing that. Okay, if there's no further discussion on D, those in favor of recommending its adoption to the town council indicate by saying aye.
Aye.
Those
Aye.
opposed, no, the ayes have it. Is it possible for us to meet again in let's say 2 weeks?
Yes.
Yep.
Let me get a calendar.
What day do you have in mind, Phil?
Come on, let me get a calendar.
I'm available the entire week of the 22nd.
I'm available the whole week also.
I'm good.
Say 2 weeks from now, which would be Wednesday, the 24th.
Sounds good.
Okay.
1 o'clock?
1 o'clock. Now, next thing on the agenda. Areas of potential improvements in disclosure forms. Last time, Mike, you laid out a possible solution to the Form A problem.
Right.
Everyone seemed to think it was a good idea. I can't envision it. We need to, can you get us something that we can look at?
Yeah, I will. Okay.
Okay, and we'll put that seriously on the agenda for the 24th, because so sooner or later. Now, you saw the email from Holly saying, once we, make the changes substantively, she'll turn it over to somebody professional to, make it right and include being able to fill it out online and sign it online,
Okay.
which would be great. I don't think we should, the next item is consider changes in rules of procedure. I think that sort of depends on clarifying what's in the ordinance. If we don't have to address that today. We've scheduled the next regular meeting. Next to last item is comments by commissioners and members of the public.
I'm fine.
Ingrid?
None.
No comments? I don't have any comments. Fred, you're a member of the public.
Yeah, no comments.
Okay. Last item on the agenda is adjournment. All those who favor adjourning at this point indicate by saying aye.
Hi.
Aye.
Opposed, no, the ayes have it. Thank you, everybody.
Well, thank
Thank you
you.
very,
I'm
thanks
going
for your
back to
work,
the
Phil.
impeachment hearing.
Yeah.
Yeah.
All right.
Go
Bye.
ahead. Bye-bye, everybody. Be
Bye.
healthy and safe.
Bye.